have a homestead exemption in Florida, can my spouse hold a homestead exemption in another state? The answer is no, because if your husband and wife, the property appraiser determines that it is a family, and therefore you're saying that the family has their homestead or permanent resident in Florida if you have homestead exemption. Whenever you sign the application for homestead, you say that you don't have an exemption in another state, and that goes to your spouse. It's even difficult whenever people are going through a divorce proceeding and they're not divorced and they're separated or separated for some time and they're not going through a divorce proceeding, whether or not both spouses can obtain homestead exemption. I know that our local property appraiser, Mike Wells in Pasco County, is really tough on this, and in fact investigates any number of people who apply for a homestead exemption to determine whether or not they have homestead in another state, and if they do, then he slaps a homestead lien against their property for all the exemption they've received. I don't know how aggressive other property appraisers are as far as investigating this, but if your spouse is getting homestead in another state, then I don't suggest you try and get homestead in Florida, because if you get caught, the homestead exemption penalties are quite severe, and it puts a lien against your property for all these back due taxes. So I would talk to the property appraiser if you do want to try and do that, and ask them before you apply for homestead exemption here in Florida in your name. If you have any other questions, give me a call at 847-2288. Thank you.